There must be.
No.
Let me finish.
Listen, no, I'm not going to let you finish.
You said I can
I
make
will
an
let
argument.
you finish making your argument.
No.
Make your argument. Then you're not going to represent yourself. Ms. Hibbert will be back in charge, and you'll be at another location remotely watching the trial.
Welcome to Solving Citizen Legal Encounters. All right, today we're going to be in Judge O'Donnell's court out of Ohio. We have a sovereign citizen in there who wants to represent himself for an upcoming trial, but the judge is not confident that he can do so. So he's going to run him through a series of questions, and then you'll see eventually that this court case is going to get heated. Okay, so let's go on in and check everything out. Let's go.
In order for it to qualify as hearsay.
Of a statement, it has to be able to be sworn in by that person making that statement under the penalty of perjury.
Everybody who sits here is under the penalty of perjury when they talk from the witness stand.
That's correct.
Right. So what comes after the jury? What type of what was that?
That was my speech was bleeding through.
What type of what are the categories of exclusions when you have jury selection?
Like I said, that would be something that I would have to get more familiar with, but I would imagine one of the categories would be, no, I don't know the per se categories, but if you have a juror who makes prejudgmental statements, I would assume that would be basis for exclusion of a juror.
Under what category of exclusion, do you know?
I'm going to assume bias. I can't actually say because I have not done that study as far as jury selections as of yet.
All right, so you got to figure out the procedure for jury selection and what the rules are, right?
Correct.
You got to figure out and study the evidence rules,
Correct.
right? Okay, what comes after jury selection?
After jury selection, so in between a jury selection started, and then you're saying after jury selection, are jurors already admitted at that point?
You tell me. You want to be the lawyer, you tell me.
I would imagine there's a opportunity to admit any jurors after a jury selection has been made based on whatever the credentials are or criteria for that basis, and then trial would start.
And how does the trial start?
I've never been to trial, Judge, so I don't have all the answers to these questions, but it's something that I can be aware of prior to trial.
Well, that would be, the opening statements would be the next thing that comes after jury selection.
That's correct.
Who goes first?
Who's ever making the accusations would be,
And who's making the accusation?
in this case, I'm assuming the state.
Okay, and then who goes after that?
It would be the accused.
What's the purpose of an opening statement?
To familiarize the jurors or the atmosphere with, I guess, the basis of their claims.
Okay. What happens after the opening statements?
I think witnesses would be called.
Okay, who calls witnesses?
So if one side doesn't have any witnesses, the only witnesses that can be called are those that are available.
That are what?
Those that are available
And how are they made available?
through summons.
Okay. How many, if you're going to represent yourself, how many witnesses are you going to call?
I think I'll be cross-examining whatever witnesses that do show up.
Okay. That's it?
That's correct.
What comes after all the witnesses are done?
Closing statements.
And who goes first?
Who's ever presenting the claim, who actually have a claim.
And that would be who?
In this case, I'm assuming the state.
Who goes next?
It would be the accused.
Is that it then?
And then there's deliberation.
Okay. What about jury instructions? Have you looked at those and what to submit?
That would be another one of the three that I'll be looking at prior
Okay.
to.
Now, you don't think that Ms. Hibbert has done a very good job here?
I actually think that she sabotaged my opportunity to have a defense in line with my constitutional rights.
Okay, why do you think she's done that? I mean, that's a conscious act, right? You're accusing her of consciously sabotaging your case. Why would she do that?
Correct. Because I've informed Ms. Hibbert on multiple occasions, which I understand if it's out of her hands, she can't make something appear out of thin air, but I've informed her that there's body cam that would support what I was claiming. I was informed by her that there is no body cam from Willoughby Police Department. I informed her from the day that I met her that my constitutional rights were violated by them entering my home without a warrant and searching and allowing others to do the same that weren't residents. I explained that to her, and it seems to me the only thing she had enthusiasm with or about was me signing waivers. And in particular, the first waiver that was signed was that at a preliminary hearing where she says to me, it doesn't really matter if you sign the waiver or not. All the police officers have to do is take the stand, and eventually an indictment will be served based on their
What's the,
based on
when
their words.
when there's a preliminary hearing, what does the judge have to find?
So, in a preliminary
What's the standard the judge has to find has been met?
in a preliminary hearing, you have to find that there's basis of the claim that's being made.
Okay.
And I didn't get an opportunity to basically be present if the claims were being made and when claims were being made
Right.
because of coercion through Mrs. Hibbert.
So the bottom line is you're facing a trial next Tuesday. And it's your belief that you're more qualified to do that job than Ms. Hibbert.
I wouldn't say the word qualification, but it depends on how you're using your qualification. Like, I say I'm more qualified to protect my liberty than she's willing to.
Okay. What happens when you ask a question on cross-examination and the state makes an objection to it and I sustain the objection? What happens then after that?
So if you sustain that objection, it would have to have been based on some type of procedural etiquette that's accustomed to how procedures work. And then that means there's guidelines that have to be adhered to.
Okay, so the state puts a witness up here. Ms. Wood finishes questioning that witness. You get up to question that witness. You ask the first question. Ms. Wood makes an objection. I sustain it. What do you do next?
So if the question can be reiterated to that quote-unquote witness, then that's what has to be done.
Okay,
If there's
what
a
if-
point
what if
to be
you-
made,
What do you mean reiterated?
readdressed,
Okay.
because obviously if you made an objection and you agreed with, you sustained her objection, you agreed that there was some guideline not being followed or
A rule being violated,
or a
right?
rule being violated.
Okay. All right, so you're better prepared to protect your liberty than she is what you're saying.
I think I'm more willing to.
See, I don't think you have the slightest idea what you're doing in a trial. Yeah, it may seem easy sitting here, but I had one guy represent himself, and by the middle of the first afternoon, he wanted his lawyer back because he had no idea. He thought he knew what he was doing. He thought he was the one that's going to be better able to represent his interests. He had no clue what he was doing, couldn't figure out what he was doing, and it was a disaster.
I'm not him though.
Well, you're not him. Of course you're not him. I've never seen somebody represent themselves that has done anything approaching a serviceable job.
Only because people who proceed pro se don't have the habitual experience as, say, a licensed attorney or even a prosecutor have of doing the same regimen over and over again and have been familiar with each other.
Okay, let me ask you this. Why are you under disability why are you prevented from having a weapon?
So in 2008, my home was invaded. I protected myself, but inevitably or unfortunately, I was charged with an assault, and that's what gave me a felony.
Okay, felonious assault in December of '08, right?
Correct.
Therefore, you couldn't own a firearm or possess a firearm, right?
That would be correct.
Okay. So what does the state have to prove on that count, having weapons under disability? What are the elements?
If I tell you any more about what the state has to prove, I'm basically helping the state defeat my
Well, they already know what they have to prove. They're the ones that brought the indictment. They know what elements they have to prove. One thing they have to prove is that you got a felonious assault conviction in '08, right? Right?
That would not be untrue. That's already listed.
I know that. So they have to prove that, right?
Correct.
So there's going to be presumably somebody here that's going to testify that you got a felony conviction for felonious assault in '08, right?
Let me ask you that, Judge. What you're saying now, would that not be the same criteria what Mrs. Hibbert did to me at the preliminary hearing by saying all the police have to do is take the stand and an
Yeah,
indictment would be served?
I don't know what one has to do with the other.
What you're saying right now, it seems eerily familiar to what she said back then.
I wasn't there, so I don't know what she said
Preliminary
back then.
waiver being signed.
All I know is that they have to prove, in order to convict you, in order for the jury to convict you, they have to prove that you didn't have the ability, you didn't have the legal ability to possess that weapon or own that weapon because you had a felonious assault conviction in '08. So they have to put on proof through witnesses that you have a felony conviction for felonious assault in '08.
So how was Ms. Hibbert being able to help me in that same scenario?
I'm not talking about whether Ms. Hibbard is going to help you or not help you. I'm saying, do you realize that there's going to be testimony that you have a felonious assault conviction in '08 as part of this trial? Did you know that?
That I understand.
Okay. So you really want to represent yourself?
Yes, I do.
Okay. All right. Do you have anything that you would like to,
Thank you, Your Honor. We would ask if the court would speak with the defendant about the remaining charges, the potential consequences, the range of punishments possible as well, to see if he understands that nature, as well as he mentioned his educational background, any mental health diagnosis or substance abuse issues that would prevent him from knowing and understanding what was occurring.
well, I guess the question is from our dialogue, does he understand those things? Do you know what the penalty is for this felony of the third degree for having weapons while under disability?
Up to 3 years, is it not?
It is. What about the possession of cocaine?
I was not informed of any other penalties or possible penalties.
I'm just gonna state for the record that that's not true.
Well,
I did inquire, but I was not informed.
okay,
Yes, you were
so I'm going to
informed.
inform you, but I doubt it, that what you're telling me is accurate, but the fifth degree felony possession of cocaine is a potential 12-month prison sentence. You understand that?
That I do.
Okay, so with the F3 and the F4, there's a potential of 48 months in prison. You understand that?
That I do.
Okay. Now, Ms. Wood brought up a good point. Have you ever been found to be mentally ill,
I have not.
diagnosed as mentally ill?
I have not.
Treated for any mental illness?
Have not.
What high school did you graduate from?
I actually dropped out of high school and went back and got my GED.
When did you get that?
2000, year 2000.
And where'd you go to college? You said you had some college?
Some colleges. Went to Ashland University and I also went to Lakeland, Erie College.
Okay. All right. Anything else that the state would like me to inquire into?
You have one moment, Your Honor. I did provide the court a waiver of counsel to see if the defendant would be willing to sign it, because he has been advised that he has an absolute right to counsel, and it is his decision to proceed pro se.
Mr. Jordan, there is a judgment entry here that I'm going to ask you to sign. It indicates that you've been, having been warned otherwise, which I advised you was a bad idea to do this, you're going to voluntarily waive your right to be represented by counsel, because you have a constitutional right to have a lawyer represent you in this case. And you don't want that. You want to represent yourself, correct?
Because of ineffective assistance of counsel.
Well, whatever the reason, it doesn't matter. You could want to represent yourself because you don't like the color of her hair. It doesn't really matter what the reason is, but you're waiving your right to have a lawyer represent you, your constitutional right. Is that correct?
I'd rather represent myself.
Right. So you're waiving that right to have a lawyer represent you.
The only right I would be waiving voluntarily.
What?
It would be the only right that I had waived voluntarily.
All right. Well, then I'm going to ask you to sign this entry. Can you take that over to him? And that's a waiver of your right to be represented by counsel.
Finally. Whew.
All right. Mr. Jordan's signature appears on the signature line, waiving his right to counsel. You filed also a motion to vacate arraignment, motion to dismiss, lack of jurisdiction, denial of due process of law. What do you want to say about that?
So, under the guidance of ineffective assistance of counsel, I attended an arraignment on December 6th, wherein which was outside of open court in compliance with Ohio Civil Rules of Procedure and that of Federal Civil Rules of Procedure.
What do the federal rules of civil procedure have to do with this?
Which the arraignment was in the lobby.
I know, but what you said, you mentioned that it violated the federal rules of civil procedure. What does that have to do with this proceeding?
Meaning, a court procedure is to be in open court defined as in a courtroom, and on the record, and being on the record, thus having a overseer or judge present, and neither of that happened.
You wanted a federal judge present?
No, but a judge would have been present as far as federal procedures.
Okay, my understanding is you waived your right to be present at the arraignment.
And that's
With a
where
not, hold on, with a not guilty plea to be entered, and the bond was set by agreement.
That's where the ineffective assistance of counsel has occurred, because during that unofficial or illegal proceeding, the way Mrs. Hibbert described to me the paper that I was signing, with a paper over the heading of the paper that it was signed, were what the state is charging or claims that they are making. So it was dated the 6th day of the arraignment. I don't know how I can waive rights of at an arraignment of an arraignment. And they were misrepresented by Mrs. Hibbert. And my belief is that that happened because there was no judge present.
What was your bond?
Excuse me?
What was your bond?
In reference to the bond conditions that
No, the bond. What was the bond amount?
$10,000.
Okay, did you post it?
During this arraignment,
Not during the arraignment. Did you post? Were you out on bond at the time of that arraignment?
during the time this arraignment happened, I was already out on bond.
Okay, so you posted it in Willoughby Court?
I was already out on bond. I
Right.
believe it was.
When you left the lobby of the jail after the arraignment waiver, did you leave the process? Did you leave the premises, or did you get locked up in jail?
Can you repeat that again?
When you exited the lobby of the Lake County Sheriff's Office where the arraignment waiver procedure was taking place, did you go to jail, or did you just leave after the
I'm
procedure?
not understanding. Are you saying on
All right.
December 6th?
December
during this
6th, did you get locked up in jail?
Let me understand. Let me
All right.
reiterate if I understand. Are you saying after the arraignment of December 6th, as I left the arraignment, did I get locked up?
Right,
That did not happen.
okay. All right, is there a waiver of arraignment in this case, Ms. Wood?
Yes, Ms. Hibbert is looking at that waiver
Okay.
right now.
Can I see that? All right, so this was the waiver of the right to be at arraignment on the indictment, the same indictment we're talking about here. It is signed by Mr. Jordan.
Under
Bond
duress
was
with
continued
all
at,
rights reserved.
The bond was continued at 10,000 cash or surety with certain conditions. So you were arraigned, you waived your right to be present in the courtroom for an arraignment and agreed to the bond that you had previously
Let me
been
be
set.
clear, Judge. That is the reason I filed for removal of a
All right, that's
counsel.
done. She's removed, okay?
Right, and that is the reason why,
All right,
because of
so-
her manipulating the waivers.
So
to be
this
signed.
motion is to vacate the arraignment. That's denied. There's a motion to dismiss for lack of jurisdiction and denial of due process. You want to
Can
address that?
you explain why the arraignment is vacated when it was not held?
It's not vacated. Your motion
Or
is denied.
denied when it's
Denied
not?
because you waived your right to be present at the arraignment.
That
Okay.
signature was coerced through her by her covering up the
Okay.
title.
Well, I've denied the motion, so let's move on to the next thing. The motion to dismiss for lack of jurisdiction, denial of due process.
So you blatantly deny my due
I
process. of law.
denied it, and we're moving on to the next thing. I'm not arguing about the arraignment. I've made a ruling on it, okay? That's it. So let's move on to the next thing.
You do know that you're acting biased right
Okay.
now. and
Do you
prejudicial.
want to move on to it, or do you want me to hear your argument? If you don't want me to hear your argument, I'll look at the paper and I'll make my ruling on the paper. You decide. You're the lawyer, so go ahead. I mean, every time you get a ruling that's adverse to you doesn't mean it's biased, okay? All right? So do you want to address the motion to dismiss, or do you not?
Read the title of the motion to dismiss for me.
No. You filed it. It's your pleading. You read it.
So yeah, motion to vacate arraignment, motion to dismiss lack of jurisdiction, which would have been during the illegal arraignment.
So
Which
is the
would-
motion to dismiss based on your belief that there's an illegal arraignment?
Not by not having a judge present, allowed Mrs. Hubbard to
Hibbert.
coerce the accused into signing a waiver that she misrepresented. Like I said, she covered the title of the waiver up as I was signing it.
Okay.
And she did not, and she explained to me as what the state simply is charging me with. So, through her misrepresenting herself as one who seeks to help me, that waiver was obtained basically through an illegal procedure.
Okay. All right, so it's based on the arraignment. The motion to dismiss is based on the arraignment?
As well as the denial of due process of law.
All right, so that motion's denied. All right. We have a jury trial that's set to begin on March 11. Ms. Hibbert is going to be present as standby counsel throughout the trial. And you can either consult with her during the trial or not consult with her. It's up to you. There is a motion filed by the state for remote testimony. Ms. Wood, you want to address that?
Thank you, Your Honor. The state filed a motion for remote testimony of the witness Destiny Thomas. The case law was cited in our motion, and the specific reasons are fact-specific to Ms. Thomas. She is currently residing in Franklin County, Ohio, which is about 2.5 hours away from Lake County, Ohio. She is temporarily residing in a domestic violence shelter. She does not have stable housing. She does not have a driver's license. She does not have a car to travel up here to Lake County, Ohio. Furthermore, she was homeless before she was placed in this shelter, and she has to abide by the shelter rules, which require her to be back in the shelter by 10 p.m. each night, or she could face and risk losing her spot in that shelter and becoming homeless again. She is worried about her items being taken should she be away from her shelter for an extended length of time to come up here, travel to Lake County, testify, and then travel back to Franklin County, Ohio. In addition to that, she is also 5 months pregnant. She informed me that she is high risk, which require additional doctor's appointments to be monitored, and she has some concerns about the physical state of her well-being, about being in the car for 2.5 hours up here and 2.5 hours back to Franklin County, Ohio. So we would ask that the court make a finding that Ms. Thomas may testify by remote means. The state would facilitate the setup of the remote testimony. Her physical demeanor would be depicted on the screen. There would be a video image of her as well as audio. She would still be sworn in and subjected to the same requirements as if a witness was here testifying on the witness stand. And she would testify to her involvement and observations prior to the police arrival involving the drugs that were charged here and the firearm that the defendant possessed, and what occurred prior to the police arrival. She is a necessary witness, and so we would ask that the court make a finding that that remote testimony be permissible. Thank you.
Mr. Jordan?
I object. Her not being present would not be considered hearsay.
How is that considered hearsay?
I would have the same effect of being able to cross-examine her with her being on the screen in a silhouette, did she say?
What?
I would have the same advantage of being able to cross-examine her as the state would have to examine anyone that I had on the stand. But I understood that she said it would be a silhouette of her. Is that correct? Is that correct? Did I hear that correct?
She's gonna testify, and she'll be right on the screen here.
Then no objection.
Okay. So Mr. Jordan does not object, so I'll permit that.
Thank you. We will facilitate that testimony.
All right, and then there's another motion that Mr. Jordan filed this afternoon at 2:13. It's a motion to dismiss corpus delicti. You want to make a copy of that for,
I
do
pulled
we have
up.
it?
I have it,
All right,
but I
never
don't
mind.
think
I don't,
standby counsel.
I don't have it. Thank you.
Sorry.
Or do you need this?
I'll keep it.
There's two
what?
motions. There's a motion to dismiss corpus delicti and a writ of estoppel.
Okay, you want to address the motion to dismiss corpus delicti, Mr. Jordan?
Yes, I filed a motion to dismiss corpus delicti, claiming, not even claiming, but pointing out that there are no injured parties to the state's claims. And there are no damaged property to the state's claims. In reference to jurisdiction, I was asking you prior, what jurisdiction were you intending to try me under? And you said, what, was the case criminal or civil? And you stated criminal. I then, like I said, sought to ask you before you left the courtroom, under what jurisdiction are you trying this criminal case? According to Article 1, Section 8, Clause 17, there are two jurisdictions, one common law and the other military or naval tribunal.
Statutory. What about a violation of the statute?
I have never heard of a statutory jurisdiction according to
Do you know
the
what-
Constitution. If you can so point me to where I can find the guidelines of procedure for this statutory jurisdiction.
So I don't have jurisdiction to try you, for the state to bring a charge under a violation of the statute?
So can you point me in the direction?
So is your motion that I don't have jurisdiction in this case?
Let me be clear on Your Honor.
Please, I'm trying to
If-
figure out, do you have that copy, Bob?
If you can point me to where I can find statutory guidelines of rules of procedure.
I'm not pointing you anywhere, you're the
But
lawyer.
they're not listed anywhere.
You're the lawyer. You tell me
They're
the
not
basis,
listed
you
anywhere.
tell me the basis of why there is no jurisdiction here, according to your motion.
Okay, things are about to heat up.
So
Make your argument.
let me ask you one.
I'm not answering questions. You're the lawyer. You present your case as to why you believe this should be dismissed. I'm not answering questions.
Let me be clear.
You're making arguments, and I'm making rulings. That's how this goes.
You've
See, this is a
already-
problem already, okay? Because you want to be a lawyer in this case, so go ahead and be a lawyer.
So, Your Honor, you've already stated that it's a criminal case proceeding against me. And I've asked you under Article 1, Section 8, Clause 17, under which jurisdiction would this criminal case proceed, whether it be common law or military tribunal. I
Okay.
haven't received an answer from that yet.
Do you have a response, Ms. Wood?
I don't know how to respond to this.
Okay. Anything else you want to say on your motion to dismiss?
Sure. Let me be clear. So the state is claiming injury to personal property? Is that the case?
Are you telling me?
I'm
Yeah,
asking the state.
They're
now.
not answering, we're not here to have a question and answer session, okay? You've got a motion, all right? So I'm telling you, you tell me any argument you have in support of your motion such
So-
that it should be granted.
So let me ask. the one
Don't
who's-
ask, no asking questions, okay?
one
Make
who's-
argue. You're a lawyer, make arguments.
So the one who's making the accusation, I know I have, under the Sixth Amendment of the Constitution, a right to know who's making the accusation and to confront that accusation for its validity. And
That's what a
you're
trial's
supposed to-
for.
And you're supposed to, as being on the bench, is to oversee that process, right?
That's right.
So
We're in a
I'm
rule on
asking the
things,
state
make
at this time,
rulings.
are these charges or claims that you're bringing against me of common law jurisdiction
not-
or
this is
military
not-
tribunal?
This is not a question and answer period between you and the prosecutors, okay?
Because, let me just be
This
clear.
is a chance for you to make your argument to
Right.
convince me that I should grant your motion.
Right, because, Judge, if it is a military tribunal, since she doesn't know how to answer it,
Well, don't.
there
she-
must
she's-
be, there must
No,
be.
no, no, no.
Let me finish.
Listen, no, I'm not gonna let you finish.
You said I can
I
make
will
an
let
argument.
you finish making your argument,
That's what I'm
okay?
doing.
No, you're asking questions.
No.
Make your argument.
My argument is, if this is a military tribunal that she's tried me under, my difference with that would be that there is no international contract in dispute. And if this is that of a common law
What
jurisdiction,
international contract? What are you talking about?
and if this is that of a, you're just supposed to listen. If this is that of a common
No,
law.
you, see, you don't, here, there's a problem that's creeping up here that's gonna rear its ugly head first thing Wednesday morning, or Tuesday morning, I fear, okay? You're not here to argue, okay? Right now, you're here to convince me on your motion. I'm not engaging in an
not
argument.
giving me an
Now,
opportunity.
I'm talking now, okay? I'm not here to have an argument with you. You're not here to have an argument with them. You address me, they address me, I make a ruling, that's it, okay? Now, I sense, the more and more we talk, that you're kind of a disruptor. And I'm telling you, on,
I object to that
I'm telling you, on Tuesday morning, if you attempt to disrupt the procedure and talk out of turn, okay, I'm not gonna put up with it. And if you do that, then you're not gonna represent yourself. Ms. Hibbert will be back in charge, and you'll be at another location remotely watching the trial, okay? So, you wanna represent yourself, you conduct yourself as a lawyer that other lawyers do when they come in here. It ain't a free-for-all. You understand that?
That's clear, Judge. I hope
All
you
right,
do
now
as
get
well.
back to your motion to dismiss.
So, as I was stating, according to Article 1, Section 8, Clause 17, there are two jurisdictions that a criminal case is tried under. One being common law, the other being that of military tribunal. And no one has answered the question of either. But if there is one to be under military tribunal, I said prior, there is no international dispute of a contract. And if it is that one of common law, I'm saying now that there is no victim who has injury to self or property making that claim present. Those are my grounds for dismissing this case. There is no person here saying that I caused them harm, injury, or to property under the common law, and neither is there a contract in dispute for the military tribunal, and neither have been addressed outside of the arraignment that no judge was present.
All right, anything else with regard to your motion?
That'll be it.
Do you have anything, Ms. Wood?
Yes, Your Honor. The state is asking for some guidance on the discovery that has been provided to Ms.
As to this
Hibbert.
motion?
Oh, as to this motion, no.
Okay, the motion is denied.
Okay.
All right, and there was another motion?
There was a motion, a writ of estoppel.
Okay, go ahead, address your writ of estoppel.
So the writ of estoppel is in reference to the coercion and unethical practices that Ms. Hubbard exhibited by or through her representation of me or misrepresentation, in which she coerced documents to be signed by making statements that were, like I said, unethical. She made the statement, if I did or did not sign the waiver, or if I didn't sign the waiver per se, there would be an indictment either way, just by the officers taking a stand. She misrepresented it at the arraignment that was outside of open court by covering up the heading of that document as I signed that document. So that's in relation to her misrepresentation and those documents per se, which were obtained.
So
through
what
her
is it you're
misrepresentation.
asking by the writ of estoppel?
For those documents to be omitted, since
What-
they were
what-
gained,
What documents?
those waivers that were
The
signed.
waiver of the right to be present at the arraignment?
Correct.
All right, I've already dealt with that, so that's denied. All right, now go ahead, Ms. Wood, as to your issue.
My issue is for some guidance from the court on the discovery that has already been all provided to Ms. Hibbard. Will that be then transmitted all to the defendant prior to trial next week?
Is that all in electronic form?
Yes, and Your Honor, we probably would be able to put it on I would have to consult with Mr. Jordan to be sure that if we put it all on a flash drive or hard drive for him, he would have the means to access it and view it. But I think it would be easy enough, because I save it all in folders, to do that for him and get him a flash drive or hard drive. And we would certainly do that as quickly as possible, being that the trial date is next Tuesday. We could probably have it to him to get this accomplished tomorrow morning.
Okay, so then,
And supplemental discovery as well. Should I leave it at the front desk for Mr. Jordan to then come pick up at his convenience at my office?
why don't you do this, since Ms. Hibbert is still part of this case, transmit any supplemental directly to her, and also leave a copy at the front desk at your office for Mr. Jordan.
Okay.
And then Ms. Hibbert, you will then, as you described, get that, what you presently have, to Mr. Jordan, and that's part of the order.
Okay. And as to the counsel-only materials such as criminal histories, those are now permitted to be transmitted to the defendant?
Yes.
Okay. Thank you.
All right, anything else from anybody?
No, Your Honor, thank you.
All right. Then everybody is to be here Tuesday morning by 7:30.
Okay, it's going to be interesting to see when this guy goes to trial how he's going to handle himself. So the judge ran him through all of that testing, and so I guess we'll see. I hope you enjoyed the video, and I'll see what I can do about getting the trial, because it was a long trial. And trials tend to be a little bit boring, but sometimes they can be really good. So maybe I'll see what I can do about just getting the good parts out of it and putting it back up, okay? Because you know I always follow up. So have a good day, evening or night. See you around next time.